Early Friday morning, federal authorities made a move that quietly sent shockwaves through Washington and Wall Street alike. According to court filings dated February 6th, U.S. Marshals arrived at a Miami residence at exactly 6:47 a.m. By the time they left, they were carrying something highly unusual in a case of this kind: Ivanka Trump's passport and travel documents. This was not a routine visit, and it was not symbolic. The seizure is directly tied to an ongoing federal investigation involving $127 million, a web of 23 shell companies, and nearly 2 years of financial tracing conducted largely outside public view. What makes this development especially significant is what happened next. Just days earlier, investigators conducted a closed-door testimony session lasting over 2 hours, testimony that few expected to become central to the case. The filings reveal that Melania Trump was questioned under oath and answered 147 separate questions. She took only one break and, notably, did not invoke the Fifth Amendment at any point. According to the official transcript, her testimony addressed internal business structures, private family communications, and financial decisions that prosecutors believe may be relevant to the broader investigation. Sources familiar with the filings say this testimony marked a turning point, reshaping how investigators view responsibility and oversight within the network being examined. The narrator of this report states he reviewed all 187 pages of the legal documents and argues that the publicly reported headlines barely scratch the surface. He says the filings outline patterns, timelines, and connections that dramatically expand the scope of the case and explain why federal authorities acted when they did. For some background, Ivanka Trump is a former senior advisor in the White House and is the daughter of Donald Trump. She runs several business companies that are registered in 6 different states. Problem, according to the narrator, is that newly discovered financial records show a pattern of money transactions that federal investigators say amount to money laundering through a group of limited liability companies, also called LLCs. He stresses that these are not his own words, but come from the legal filings. Here is a quick timeline of the case. Months ago, a grand jury was brought together in Manhattan, and subpoenas, which are legal orders to hand over documents or testify, were sent out. Ivanka's lawyers started fighting against those requests for documents. A few weeks ago, a federal judge turned down her attempt to block those requests and ordered her to fully comply. Then, just days ago, everything changed. Melania walked into a federal building in Washington, D.C. 2 hours later, she walked out. The very next morning, U.S. Marshals showed up at Ivanka's door. The narrator says the order of those events is very important. Based on information that has been made public, this investigation started with the Trump Organization and then grew bigger. Investigators found something within the family's business structure that prosecutors thought was worth pursuing, and Melania, for her own reasons, decided to work with them. The narrator says that is the basic setup, and that the documents explain the reasons behind it. He went through them 3 times over the weekend and pulled out the most important parts. The first key document was filed on Friday. On page 43, it says, and this is a direct quote, that the defendant helped move money from Trump Organization subsidiary accounts to a company registered in Delaware that had no clear, legitimate business reason to exist. The narrator says that is not his own opinion, but what the legal filing actually states. It means money was moved, and where it ended up does not make sense based on the paperwork. But the part that really caught his attention is on page 89 inches, a different section. According to the court documents, between March 2023 and November 2024, Ivanka Trump's signature showed up on 31 separate approvals for wire transfers that added up to $84.7 million. The money went to a holding company in Cyprus, a subsidiary company in the Cayman Islands, and a company registered in Nevada that has no employees, no income, and no office. When you put all of that together, there is a clear pattern. Money left Trump Organization accounts, was sent through Ivanka's personal business network, and ended up in companies that only exist on paper. All of this is documented on pages 91 through 103 of the filings. Now, here is something that almost no one is reporting. There is an exhibit labeled Exhibit F that is buried on page 147. It shows that verified financial records indicate Ivanka personally took out $3.2 million in cash equivalents over a period of 14. Early Friday morning, federal authorities made a move that quietly sent shockwaves through Washington and Wall Street alike. According to court filings dated February 6th, U.S. Marshals arrived at a Miami residence at exactly 6:47 a.m. By the time they left, they were carrying something highly unusual in a case of this kind: Ivanka Trump's passport and travel documents. This was not a routine visit, and it was not symbolic. The seizure is directly tied to an ongoing federal investigation involving $127 million, a web of 23 shell companies, and nearly 2 years of financial tracing conducted largely outside public view. What makes this development especially significant is what happened next. Just days earlier, investigators conducted a closed-door testimony session lasting over 2 hours, testimony that few expected to become central to the case. The filings reveal that Melania Trump was questioned under oath and answered 147 separate questions. She took only one break, and notably did not invoke the Fifth Amendment at any point. According to the official transcript, her testimony addressed internal business structures, private family communications, and financial decisions that prosecutors believe may be relevant to the broader investigation. Sources familiar with the filings say this testimony marked a turning point, reshaping how investigators view responsibility and oversight within the network being examined. The narrator of this report states he reviewed all 187 pages of the legal documents and argues that the publicly reported headlines barely scratch the surface. He says the filings outline patterns, timelines, and connections that dramatically expand the scope of the case and explain why federal authorities acted when they did. For some background, Ivanka Trump is a former senior advisor in the White House and is the daughter of Donald Trump. She runs several business companies that are registered in 6 different states. The problem, according to the narrator, is that newly discovered financial records show a pattern of money transactions that federal investigators say amount to money laundering through a group of limited liability companies, also called LLCs. He stresses that these are not his own words, but come from the legal filings. Here is a quick timeline of the case. Months ago, a grand jury was brought together in Manhattan, and subpoenas, which are legal orders to hand over documents or testify, were sent out. Ivanka's lawyers started fighting against those requests for documents. A few weeks ago, a federal judge turned down her attempt to block those requests and ordered her to fully comply. Then, just days ago, everything changed. Melania walked into a federal building in Washington, D.C. 2 hours later, she walked out. The very next morning, U.S. Marshals showed up at Ivanka's door. The narrator says the order of those events is very important. Based on information that has been made public, this investigation started with the Trump Organization and then grew bigger. Investigators found something within the family's business structure that prosecutors thought was worth pursuing, and Melania, for her own reasons, decided to work with them. The narrator says that is the basic setup and that the documents explain the reasons behind it. He went through them 3 times over the weekend and pulled out the most important parts. The first key document was filed on Friday. On page 43, it says, and this is a direct quote, that the defendant helped move money from Trump Organization subsidiary accounts to a company registered in Delaware that had no clear legitimate business reason. to exist. The narrator says that is not his own opinion, but what the legal filing actually states. It means money was moved and where it ended up does not. Makes sense based on the paperwork. But the part that really caught his attention is on page 89 inches, a different section. According to the court documents, between March 2023 and November 2024, Ivanka Trump's signature showed up on 31 separate approvals for wire transfers that added up to $84.7 million. The money went to a holding company in Cyprus, a subsidiary company in the Cayman Islands, and a company registered in Nevada that has no employees, no income, and no office. When you put all of that together, there is a clear pattern. Money left Trump Organization accounts was sent through Ivanka's personal business network and ended up in companies that only exist on paper. All of this is documented on pages 91 through 103 of the filings. Now, here is something that almost no one is reporting. There is an exhibit labeled Exhibit F that is buried on page 147. It shows that verified financial records indicate Ivanka personally took out $3.2 million in cash equivalents over a period of 14 months. The pattern of those withdrawals is very specific. She never took out more than $9,500 at a time. The narrator asked people to read that again. The amount was always $9,500. The reason that matters is that the federal government requires banks to automatically report any transaction of $10,000 or more. If you stay under that amount, no automatic report gets filed. The legal filing calls this structuring, which means deliberately breaking up transactions to avoid triggering those reports. Prosecutors say this is evidence that she did it on purpose. As a result of all this, Ivanka's passport was taken away while she waits for trial. Her bail was set at $15 million. Her travel has been limited to the Southern District of New York. All of this happened within 72 hours of Melania's testimony. Here is where it all connects. The official transcript says Melania told investigators that she was present for multiple conversations in which Ivanka talked about keeping transactions below the reporting limit. There is a direct quote from the filing where the witness identified as MT, which stands for Melania Trump, said that the defendant told people to keep it under 10, always under 10. That is found on page 156, paragraph 14. There is one more important detail. On page 162, prosecutors argue that Ivanka had special knowledge about federal reporting rules because of the job she held in the White House. They are not just saying she did it, they are saying she knew exactly what she was doing and why. To sum up the evidence, there are 31 wire transfers totaling $84.7 million. 3 offshore companies that do not actually operate any business. 89 cash. Withdrawals that were all kept under $10,000, testimony from a direct witness, and a pattern that stretches over 20 months. Legal experts are saying this is one of the most thoroughly documented money laundering cases involving a former White House official in recent memory. It is not just one piece of incriminating evidence. It is a whole collection of evidence, and it is all available in public filings now, and that is only the financial evidence. Melania's testimony is a separate and significant part of the story. However, the narrator says he wants to be fair and present the other side because the defense does have some valid points. Conservative critics say this is selective prosecution, basically a political attack using the legal system. And some of their arguments have merit. First, the timing is suspicious. The investigation got more aggressive right before election season. That could be a coincidence or it might not be. Second, There is the issue of family dynamics. Using Melania's testimony against Ivanka is something the defense says is manipulative, arguing that prosecutors pressured one family member to turn against another. Third, the structuring charge itself is not as straightforward as it sounds. Defense lawyers point out that withdrawing cash in amounts under $10,000 is not automatically a crime. Prosecutors have to prove that the person did it on purpose to avoid the reporting rules. Alan Dershowitz, a well-known law professor from Harvard, said that structuring charges require proof of intent to avoid the reporting requirements, and that patterns by themselves do not prove someone committed a crime. The narrator says he does not agree with everything the defense says, but their arguments are not meaningless either. They point out that there is no direct evidence from the transactions alone proving Ivanka knew about the reporting laws. They question Melania's reliability as a witness given the tensions within the family, and they raised concerns about prosecutors going too far. Even Jonathan Turley, a constitutional law professor at George Washington University, said this case raises serious questions about using family testimony and the timing of the charges. The narrator says he is not trying to tell anyone who is right. Here is how both sides see it. The prosecution's version is that the evidence supports money laundering, including wire transfers, shell companies, and structured withdrawals, and that it is a textbook case. The defense's version is that the evidence shows sloppy bookkeeping, the normal messiness of a family business, and political targeting, not actual crime. Both interpretations are possible, and that is what makes this case complicated. Here is what the defense team filed on Thursday. Their official documents say that Ivanka's lawyers argue the offshore companies had real business purposes, including international licensing deals and contracts for managing her brand. They submitted 47 pages of business records, contracts with foreign companies, and revenue statements. Their position is that the money moved because the business operations moved, and there is nothing suspicious about it. They also directly attacked Melania's testimony. In their legal motion on page 23, they wrote that the witness, identified as MT, has significant personal and financial reasons to give, testimony that helps the prosecution. In plain language, they are saying Melania might have her own reasons for cooperating that have nothing to do with telling the truth. Family relationships are complicated, and everyone following this story knows that. There is also an uncomfortable reality for the prosecution. Prosecutors have brought weak structuring cases in the past, and they have lost. The law requires proving that someone knew about the $10,000 reporting limit and deliberately kept their transactions below it on purpose. Just showing that it happened is not enough. That is a real challenge for the prosecution. A defense attorney named William Brennan, who has 37 years of experience in federal criminal defense, said the government needs more than just a pattern. They need proof that she specifically did this to avoid the reporting requirements. That is what the legal battle will be about. The narrator says he can only share what the documents show, and they show that both sides have strong points. The trial will not be easy for either side, but there is a reason the judge allowed the passport to be taken. There is a reason the bail was set at $15 million. There is a reason Melania's testimony was given behind closed doors instead of in open court. The prosecution believes they have a strong case. This did not come out of nowhere. For more background, over a year ago, the Manhattan District Attorney's Office expanded its investigation from the Trump Organization to individual family members. Subpoenas were sent out. In the months that followed, Ivanka's team fought against every request for documents. They claimed legal privilege and executive immunity, but all of those arguments were rejected by the court. A few weeks ago, the grand jury extended its session, which meant they were not finished. A source familiar with the investigation told reporters on the record that they knew the investigation had shifted specifically to Ivanka. Because the document requests became very focused and targeted, what happened next is what usually happens when someone fights subpoenas. Investigators became more curious and started pulling on threads. The pattern they saw was delayed compliance with court orders, incomplete document submissions, and inconsistent statements from Ivanka's legal representatives. Every time that happened, the investigators looked even harder. The sealed indictment, which is formal, criminal charges kept secret, was filed weeks before Friday's arrest. Prosecutors kept it quiet and waited. As for Melania's role, according to court documents, prosecutors reached out to Melania in late January and offered her a proffer session, which is basically a meeting where someone can share what they know. She accepted, and that is when the case changed direction. Before her testimony, prosecutors had documents and bank records. After her testimony, they had context. They understood the motivation behind the transactions. And they had direct witness statements about private conversations until Thursday. This was a case built entirely on paper. Thursday made it personal and human. One family member sat under oath for 2 hours and talked about another family member. That is the context that explains why Friday happened the way it did. Now for the details of what happened on Friday morning. According to court documents, 4 U.S. Marshals arrived at Ivanka Trump's home on Star Island in Miami at 6:47 a.m. Eastern Time on Friday, February 6th. They showed her a court order and demanded her passport. Her lawyer was on the phone within minutes and called the judge on duty asking for an emergency order to stop the seizure. That request was denied. The court said there was enough evidence that she was a flight risk because of her international business connections and her access to private planes. That denial order was filed at 8:12 a.m. There was no room for negotiation. What happened after that moved quickly. The passport was handed over at 7:23 a.m. A bail hearing was scheduled for that afternoon. By Friday evening, $15 million in bail had been secured. GPS monitoring was put on her before she left the courthouse. All of that happened in about 4 hours. While the media was focused on the passport story, something else happened that most people missed. The court made a document called Exhibit G public. That exhibit contains 67 pages of communications, including emails, text messages, and transcripts of voice messages. Then the judge did something unusual. She ordered Ivanka's legal team to hand over all electronic devices that had been used for business communications since 2021. That includes laptops, phones, and access to cloud storage. The deadline for handing everything over is Wednesday, February 11th. Former U.S. Attorney Barbara McCune called this move extraordinary. She said it was not a reaction to events, but a carefully planned strategy. You can see it in the sequence of events. On Thursday, Melania testifies. Friday morning, marshals arrive. Friday afternoon, sealed. Exhibits are made public. Friday evening, the device surrender is ordered. Prosecutors were not scrambling or reacting. They had a plan, and they followed it step by step. One detail that stands out is that the order to hand over devices came after the passport was seized, not before. That means prosecutors think there is more evidence to find. They already have what Melania told them. Now they want to Check it against Ivanka's own communications. They are looking for deleted messages, conversations on encrypted apps, and anything that either confirms or contradicts what Melania said under oath. This is the moment that will determine whether the case gets stronger or falls apart. The devices will tell the real story. Now for what? Legal experts are saying. Rinaldo Mariotti, a former federal prosecutor with 15 years at the Department of Justice, said that seizing a passport at this stage means prosecutors have strong evidence and a real concern that the person might try to leave the country. In simple terms, they do not take that step unless they are confident. Daniel Goldman, a former assistant U.S. attorney, said Melania's testimony is the key to the whole case. He noted that family witnesses are incredibly powerful and incredibly rare. The important thing to understand is that family members almost never agree to cooperate with prosecutors. When they do, juries take it very seriously. Even Tim Parleratore, who previously served as an attorney for Donald Trump, admitted that the structuring charges are serious. He said that if the pattern is as well documented as the filing suggests, the defense has a lot of work ahead. When people on both sides agree that the situation is serious, that should tell you something. The general agreement among legal experts is that the volume of evidence is unusual for this early stage of a case, that Melania's cooperation completely changes the situation, that the device surrender order suggests prosecutors expect to find more, and that the passport seizure shows they have high confidence. But there is disagreement, too. Criminal defense attorney Carolyn Pissy, a former federal law clerk, said that structuring cases are extremely hard to prove, and that the question of intent is where prosecutors often fail. Constitutional law professor Ilya Shapiro added that people should be careful about celebrating when political figures are prosecuted because the precedent it sets matters. The narrator gives his own assessment after reviewing everything. The prosecution has a lot of material, including documents, witnesses, and patterns. The defense has complexity on its side with legitimate business arguments, claims of family bias, and questions about intent. Neither side has a guaranteed win. Despite what the headlines suggest, this is not an easy case. But the passport seizure is a meaningful signal. Judges do not order that casually. They looked at the evidence and decided that Ivanka Trump might try to flee the country. That is not a neutral sign. Former Department of Justice official Harry Litman said simply that determining someone is a flight risk requires probable cause, and the judge saw enough to believe she might leave. Courts do not guess. They make assessments based on evidence. The narrator then explains why this case matters to ordinary people. If you own stock in any business connected to the Trump name, you should pay attention. Trump media stock dropped 12% on Friday, and Trump Organization bond prices fell 8% by the time the NS market closed. Legal uncertainty causes that kind of financial damage. Your investment portfolio might be affected without you realizing it through index funds, real estate investment trusts, or banking sector investments. Some investors are reportedly reviewing their exposure to politically sensitive assets and talking with financial advisors about adjusting their investments. This case also sets a legal precedent. In the future, if you are ever involved in a business dispute or a legal matter, the rules about family members testifying could apply to you. For example, imagine your spouse knows something about your finances or your adult children were present during a conversation. Under current law, prosecutors can approach those people, offer them immunity from prosecution, and ask them to testify. This case shows they are willing to do exactly that. The protection known as spousal privilege means married couples generally cannot be forced to testify against each other. But Melania was not forced. She agreed to testify voluntarily. And when it comes to stepchildren, there is no privilege protection at all. According to the court documents, the investigation has identified 23 people who received money from the network of shell companies. These include business associates, contractors, and consultants. Some of them have already hired lawyers, and others are reportedly cooperating with investigators. It affects everyone in that circle. There is also an uncomfortable truth that nobody wants to say out loud. If you have ever broken up financial transactions to avoid reporting requirements, you are watching your own methods being prosecuted. This applies to small business owners, real estate investors, and anyone who runs a business that handles a lot of cash. The government is using this case to send a message not just about the Trump family, but about anyone who treats those transaction reporting limits as optional. If you have ever deliberately kept your cash withdrawals under $10,000, you are part of this conversation, whether you want to be or not. The narrator says he is not trying to scare anyone, but that is what the legal situation suggests. In terms of practical steps, informed people are reviewing their transaction records with accountants, making sure they have documentation showing legitimate business reasons for any cash movements, and asking their financial advisors whether they might be at risk. The IRS has increased its enforcement of structuring violations by 340% since 2020. This case is the most high-profile example, but it is far from the only one. If you run a business that deals with cash, or if you have ever split a large purchase into smaller transactions, this is relevant to you. The narrator recommends consulting a professional and understanding the rules. On a bigger level, whatever happens to Ivanka Trump will influence how prosecutors across the country handle high-profile financial cases. If they win here, they will get more aggressive everywhere. If they lose, defense lawyers will have a blueprint to follow. Either way, the rules for these kinds of cases are being shaped right now. Ivanka's response made the situation worse. Within hours of her passport being taken, her team put out a statement calling the prosecution politically motivated persecution. The statement read, "This is a weaponization of justice against the Trump family that every American should fear." That statement was shared 2.4 million times on social media. The hashtag about freeing Ivanka was trending for 11 hours on Friday, and fundraising emails were sent out within 30 minutes. Prosecutors responded through a spokesperson by saying the evidence speaks for itself and that their office does not comment on political talk. Then the judge did something unusual. She issued an order stopping both sides from making public statements that could influence the jury pool. This is called a partial gag order, and it went into effect immediately. That means Ivanka cannot keep going on television and in the media. She cannot keep calling the case political. She cannot raise money directly from the case. Her legal team objected and filed an emergency appeal on Sunday night. That appeal was denied this morning. The order stays in place. So now Ivanka's situation is very restricted. She cannot travel internationally. She cannot talk publicly about the case. She cannot leave the Southern District of New York without getting permission from the court. She went from running international businesses last month to having her movements tracked by GPS this week. The situation is not calming down. It is getting more intense. The defense filed 3 separate legal motions on Saturday. One challenges the passport seizure. Another challenges the gag order. The third challenges the timeline for handing over electronic devices. All 3 are still pending, and the judge's response is expected by Wednesday. Several things remain unclear. First, what exactly did Melania say? The transcript of her testimony is only partially available to the public. What? We have our excerpts that prosecutors included in their filings, not the full 2 hours. Second, why did Melania cooperate? No deal giving her immunity has been publicly disclosed. No charges against her have been mentioned. She walked in voluntarily, and that does not happen without a reason. Here is what is coming up. The federal court has a status conference scheduled for Wednesday, February 11th. Ivanka's team is expected to argue for changes to her travel restrictions. Prosecutors are reportedly getting additional exhibits ready to present to the court. The date to really watch is Friday, February 13th. That is the deadline for handing over the electronic devices. Whatever is on those laptops and phones will become part of the evidence. If messages were deleted, forensic experts will find them. If encrypted messaging apps were used, prosecutors will know. If the communications match what Melania testified to, the case gets stronger. If they do not match, the defense gets ammunition. Friday is the turning point. Also coming up, the grand jury meets again on Thursday, February 12th. Additional charges are still possible. The indictment that has been made public might not be the final version. Here is where everything stands right now. Ivanka Trump has had her passport seized, is out on $15 million bail, and is being monitored by GPS. Melania Trump's testimony is complete and no charges have been filed against her. The order to hand over electronic devices has a deadline of Wednesday, February 11th. No trial date has been set yet. Additional charges are possible, and the grand jury is meeting again on Thursday. The key dates to watch are Wednesday, February 11th for the status conference, and hearing on the defense motions Thursday, February 12th for the grand jury session, Friday, February 13th for the device compliance deadline, and Monday, February 16th for the expected prosecution response to the defense motions. Several things have not been made public yet, including the full transcript of Melania's testimony, the defense witness list, and any potential cooperation agreements with other people involved in the investigation. The clock is ticking. The defense has 4 days to hand over the devices, 4 days to try to get changes to the gag order, 4 days before the grand jury might add more charges. Meanwhile, prosecutors already have what they need to move forward, and they are not waiting. This case has moved faster in 5 days than some. Cases move in 5 months, and the narrator says that is clearly intentional. When you seize someone's passport, you are sending a message to everyone, including the person charged, that you are serious, and prosecutors are serious. That is where things stand. Ivanka Trump is restricted, monitored, and fighting on multiple legal fronts. On the surface, this is about a former White House advisor facing serious federal charges. But Melania's role is the real story. Why she cooperated, what she actually said, and whether her testimony holds up under scrutiny are the key questions. The device surrender will reveal whether prosecutors can back up her testimony with hard evidence, or whether they are relying only on her words. The judge's tone at Wednesday's hearing will matter. How she handles the defense motions will signal where this case is heading. The story is not over. It is still developing. What we know is that the evidence is substantial. The family situation is unlike anything seen before, and both sides are being aggressive in their legal strategies. What we do not know is whether any of this will end in a conviction. Cases like this have fallen apart before. High-profile targets, political pressure, and aggressive prosecution that could not finish the job. This case might be different because the documentation is unusual and the witness is unprecedented. But we are still in the early chapters of a long story.